Well, good afternoon, everyone. Thanks so much for joining us today for another one of our informational webinars. For those that don't know me, I'm Stephanie Otts. I'm the director of the National Sea Grant Law Center, and we're so glad that you were able to join us today. So, overview of our webinar for today. We're just going to do a few general updates and then quickly cover the following topics: the Fishery Participants Program, some of the new USDA programs that are coming online, liability concerns as our states reopen, PPP loan forgiveness, and then there should be plenty of time for questions and answers. We are recording the webinar and we'll post it on our website afterwards for any of your colleagues that aren't able to join us live. And if you have questions, please use the chat box at any time to ask your questions. And then we will also have, as I mentioned, a question and answer period. So I think I see a lot of repeat folks on the webinar today, but for those that might watch it online either, just a quick reminder that the National Sea Grant Law Center is one of 34 Sea Grant programs. We're based at the University of Mississippi School of Law, and we were established to provide non-advocacy legal research, outreach, and education services to the Sea Grant network. And wanted to remind everyone that we do have a COVID-19 resources webpage that we update quite frequently. That's just a screenshot of where you can find us easily by just going to the National Sea Grant Law Center's webpage. You can link from the home page, but the direct link is also available on the slide. Just by way of general update, I wanted to mention some of the new information that is on our webpage since our last webinar. We have added sections on the USDA food purchase programs and the coronavirus food assistance program that Zach will talk about here in just a minute. But if you want information about those programs, that is now available on our website. Also wanted to mention that we do answer direct questions from Sea Grant programs related to COVID-19, separate from the updates that we're providing by webinar. Here are just some examples of questions and research that we've done for programs in the last couple of weeks, looking at the impact of stipends on unemployment compensation. For instance, if your program was thinking of paying fishermen or somebody else to contribute to some of your programming, that could impact their unemployment compensation. Liability of nonprofits for resuming activities. We are happy to review informational fact sheets. We've also answered questions seeking clarification of loan calculations or the various programs. So we're here to assist, and we want to know what questions you're encountering and what information you need, so please reach out to us at any time. Just real quick, I'm not going to go into details with this, but some of you may have questions about this or you're getting questions from stakeholders. So the Fisheries Participant Program is now up and running. The CARES Act allocated $300 million for economic assistance to fishery participants. To be eligible, the person or individual must have an economic revenue loss of 35% as compared to a 5-year average, or negative impacts to subsistence, cultural, or ceremonial fisheries. This money was allocated to NOAA. NOAA has routed the money through the Interstate Marine Fishery Commission, so the Atlantic, Pacific States, and Gulf of Mexico Marine Fisheries Commissions, as well as Puerto Rico and the U.S. Virgin Islands. The state allocations were set by NOAA, but then the states need to develop their spend plans, which they'll submit to the commissions to then access those funds and distribute them to fishery participants in their states. So eligibility determinations for whether you've had an economic revenue loss or this negative impact will vary by states. And so fishery participants in your state should be reaching out and working closely with their marine fisheries program staff to figure out, what might be coming down the line with respect to documentation and other things like that. And so we'll be tracking this as more information comes out, but that's the brief overview. And with that, I'll turn it over to Zach to talk about some of the new or ongoing USDA programs.
Thanks, Stephanie. Hi, everyone. Two different programs that we're going to be reviewing today are the USDA Section 32 food purchases, and then the Coronavirus Food Assistance Program, or CFAP. So first, let's talk about Section 32. Section 32 food purchases specifically refer to Section 32 of the Agricultural Act of 1935, which authorizes the USA to purchase US processed and produced agricultural commodities. These commodities are then distributed through the USDA's F&S network to groups such as food banks that operate the Emergency Food Assistance Program. So this program, in theory, operates all the time, but in light of the disruptions caused by COVID, both to supply and demand, they decided to expand the program. Relevantly for us, seafood is included in this program, but only a specific subset, an enumerated list. The USDA announced that under Section 32, it's going to be purchasing $20 million worth of Alaskan pollock, and then $20 million worth of Atlantic haddock, pollock, and redfish. So just to clarify, 20 million for Alaskan pollock, and then those other three kinds of fish are in one group, all lumped under $20 million together. For now, eligible producers, so those who may produce, process pollock, either Alaskan or Atlantic, and then haddock, redfish, should become a USDA vendor if they aren't one already. This is specifically because the USDA is going to offer and accept solicitations through its web-based supply chain management system, or WBSCM. Those of you who are interested should keep an eye on the Agricultural Marketing Services website, as they will start posting solicitations in June. And in addition to our website, where Stephanie mentioned we have more information, we've included a link at the bottom that will bring you straight to the USDA webpage. On the Coronavirus Food Assistance side of things, or CFAP, this is a slightly different concept. This is a multi-billion-dollar USDA direct aid program for farmers that are impacted by COVID. So Section 32 is food purchases, buybacks made by the government. This is just direct aid. There isn't an exchange of goods for this aid. Specifically, the CARES Act allowed for assistance to farmers who are impacted by COVID disruptions. And in order to be eligible, the producer has to be in the business of commodities that suffered a loss in value of 5% or more between January and April of 2020, or alternatively, they could have just faced additional marketing costs due to COVID. If there was a huge backlog, say, of supply or inventory, increased marketing costs would make them eligible for this program. On the aquaculture side of things specifically, it is eligible, but the USDA needs a little more time to figure out just which aquaculture commodities qualify under those just identified terms. The regulations do specifically mention shrimp and salmonids, but the caveat there is that they still want more data to make sure that there is in fact that 5% loss in value between January and April. However, those are not the only fish that are eligible. Any aquaculture producers who reach out to you should respond to the USDA's Notice of Funding Availability that was posted in the Federal Register. They can submit either personal data that just reflects the prices that they had January and then April. They can talk about inventory and marketing costs, and those comments can either be at the individual level, the data, meaning can be at the individual level, or they can refer to aggregate, state, regional, national numbers. So a couple different ways for interested parties to make their voices heard and see if they're eligible. And there's another link there. And with that, I will hand it off to Tara to talk about liability.
Thank you, Zach. All right, so I'm going to talk about some liability concerns. So as states are lifting their stay-at-home orders and beaches, parks, schools, and businesses are starting to reopen, we have heard a few questions about whether these activities can resume safely. What are the legal liabilities for businesses and institutions who decide to start back up? And what are the ways to manage these legal risks? I'm going to give just some general info since tort law varies from state to state, so please keep that in mind as I'm going. So first of all, most likely any liability claim would be based in negligence, and common law defines negligence as conduct which falls below the standard established by law for the protection of others against the unreasonable risk of harm. And to prove negligence, a plaintiff has to show three elements. First of all, that the defendant owed a duty to the plaintiff, that the defendant breached that duty, and that the breach proximately caused injury to the plaintiff. So in a negligence action, a plaintiff would first have to prove that the defendant owed the plaintiff a duty of care. And the duty of care owed to the plaintiff really depends on the circumstances and, again, on state law. But very generally, the duty would be to act with due care to provide a safe environment to customers or the community. So what does it mean to act with due care? These are measures that an ordinary, reasonable, and prudent person would use under the same or similar circumstances. What does that look like? So in this case, with coronavirus, a program could show that it took due care in running events during the pandemic by following any social distancing, PPE, hygiene guidelines developed by federal, state, or local governments. For example, the CDC guidelines were published for hosting community events. And by following these guidelines, it could help protect employees and program participants, as well as reduce liability. And I have a link there, but there are lots of guidelines for lots of different circumstances. All right, so next we're going to talk about some possible limits on liability. One limit on liability for states is the doctrine of sovereign immunity. This is the doctrine that says a state is immune from tort suits. And generally, sovereign immunity applies to state subdivisions, which would include departments and state universities. Whether this would apply to Sea Grant programs depends, again, on state law and the setup of your program. For example, like New Jersey Sea Grant is considered a nonprofit, so sovereign immunity wouldn't necessarily apply to that program. But many states have tort claims acts that have waived sovereign immunity. However, most of the tort claims acts also provide exceptions to the waiver, meaning that the states retain immunity in certain circumstances. One of these circumstances is the discretionary function exception. And under this exception, the state is immune from suit for decisions made by state employees or agencies that require the exercise of discretion or judgment. So another defense to liability would be the assumption of the risk. This just means that a person assumes a risk where he or she voluntarily subjects himself or herself to a known peril. For example, if you go on a hike in the summer, you assume the risk that you might pick up a tick or two. And I think it's probable that you could argue that a plaintiff who attended an event during a pandemic was assuming the risk that he or she would contract the virus. There's been extensive media coverage about the recommendations to stay 6 feet away and to wear face masks. Excuse me.
Tara may have had an
Okay,
issue with
sorry.
her device. So no, that's okay. Go ahead.
Okay, so as I was saying, it's probable that you could say the plaintiff assumed the risk that he or she would contract the virus. And they would have at least some degree of culpability if they claim to have contracted COVID-19 while at an event or on a business's premises, especially if that individual failed to follow the social distancing guidelines established by the CDC or other state or local government. So now we're going to move on to talking about one way to address the risk for liability, which are liability waivers. So can Sea Grant programs or other businesses use a liability waiver sorry, to protect them from negligence if someone sues saying that the program or business is negligent in exposing them to the virus? The answer is we don't know yet. This specific issue hasn't been heard by a court, but I'm sure that it's coming. So in general, are waivers necessary? We sign waivers all the time when we join a gym, sign into a trampoline park, sign our kids up for camps, and it's highly possible that we may be asked to sign waivers for COVID-19 as well. So whether these are enforceable to bar negligence varies significantly by state. I'm just going to go over a few things that a court might consider in a claim like this, but again, it all depends on state law. So first, the waiver language should be clear and unambiguous. In other words, would a participant or customer reasonably understand that he or she was releasing a program or business from liability for injury or illness? If not, the waiver is likely unenforceable. And then second, courts are unlikely to enforce waivers of liability that waive liability arising from intentional, reckless, or grossly negligent conduct. And courts define gross negligence as an extreme deviation from the ordinary standard of care or a conscious disregard for the rights and safety of others. So for example, a liability waiver probably would not protect a business owner who had coronavirus symptoms or a positive diagnosis from liability to an exposure claim. This would be considered reckless or grossly negligent conduct. And then finally, courts will consider the public policy implications of enforcing waivers of liability and generally will not enforce waivers if the individual waiving potential claims cannot negotiate the terms of the waiver. So then next, I wanted to just briefly discuss the elements that might be in a liability waiver. So first, waivers will have an assumption of the risk clause. We talked about that a little bit. It generally lists the inherent risks which cannot be mitigated by the business's care. And this clause is intended to disclose these risks and prevent a business from being sued for events that were out of the business's control. So in the instance of a coronavirus liability waiver, it might say that an attendee at an event assumes the risk of contracting the virus. And then next is the waiver clause. This is intended to prevent liability from injuries stemming from ordinary negligence. As I mentioned earlier, while courts sometimes accept waivers of ordinary negligence, they will not allow waivers for gross negligence, recklessness, or intentional conduct. Then there is the indemnification clause. It's called the hold harmless clause sometimes. It generally insulates the parties from loss or damage. Courts uphold these typically between sophisticated businesses, but they're reluctant to enforce them when an individual indemnifies a business. And then finally, there's the agreement to comply clause. This is the agreement to comply with essential policies. This helps establish a contributory negligence defense if a party's injured because of that party's own failure to comply with an essential rule. So in the instance of COVID-19, this might outline the essential social distancing policies that the party will agree to comply with. So that's all I have. And next, I'll turn it over to Kathy.
All right, so I'm going to talk a little bit about some Paycheck Protection Program issues that we're seeing right now. And I'm going to talk some about the loan forgiveness application and guidance that just came out in the last week. But as I go through it, I'll note then that we really are going to issue kind of more information in the future about what those programs are. Some of the provisions are pretty dense, so we didn't want to get too in the weeds in this webinar, but I am going to cover kind of the provisions that businesses would be facing right now, and so that as they're spending the money, the things they need to know now that the forgiveness application is out. But to start off, we just wanted to do a couple quick reminders based on the PPP, based on questions we've been getting in the last week or so. And the first of that is that the Paycheck Protection Program applies to all small businesses that meet the eligibility requirements. So though in these webinars and some of the tip sheets we've put out, we've been focusing on seafood related businesses, any business that meets the eligibility requirements can apply for the programs. And then another repeated question we're getting, because so many fishing businesses use independent contractors instead of employees, is that the main purpose of the PPP, again, is to pay employees. So sole proprietors that are using independent contractors are able to get loans to pay themselves and any W-2 employees that they employ. The PPP is not designed for a business to help the independent contractors that they use. So an employer can't help an independent contractor through this program. But again, those independent contractors are eligible themselves to go to apply and receive loans to pay themselves. And unlike the first round of PPP funding, there is still funding available in this second round that opened April 27th. So if there are independent contractors or sole proprietors who haven't applied and are still interested, that funding for right now is still available. The second issue that we just got asked a question about has to do with this seasonal calculation that we had sent an email about a few weeks ago. And so the SBA issued an interim rule that applies to seasonal businesses, and it was meant for businesses that would be hiring employees and issuing, W-2s to in the summer months. And so previously, seasonal businesses could only use a date of 12 weeks between either February 15th or March 1st and June 30th to calculate what their loan amount would be. And that rule allows the businesses to instead elect May 1st through September 15th, any 12-week period that would apply to them. And so we've gotten a question about whether or not a commercial fishing business that is using independent contractors can use the seasonal calculation instead of the calculations that apply to sole proprietors. And so in looking at it and looking into the rules, we discovered that the rule itself uses the term seasonal employers. So we really think that it's applying to businesses that are hiring employees. And so if a business is not hiring employees and just using independent contractors, we really don't think the rule applies to them. And further, if you think about it, if you have no employees on payroll and you're just using independent contractors, when you're doing your loan calculation amount, it's not really going to change because you're not increasing your payroll by hiring people over the summer months. And so that's definitely a confusing provision because the SBA uses the term both seasonal business and seasonal employers. So we just wanted to point out that issue that we see with that rule. So I'm going to spend the rest of our time today talking about the PPP loan forgiveness provisions. And I just wanted to give, a broad overview of some of the issues that we're seeing. And so to review, and for those of you guys who haven't looked at this before, under the PPP, payroll costs and certain non-payroll costs are forgivable. And so payroll costs are capped at $100,000 for each employee, prorated over the loan period. and only certain non-payroll costs are allowed to be forgiven. So those include mortgage interest, so not mortgage principal, and you can't make any prepayments of either principal or interest, lease and utility payments, and the loan application, forgiveness application specifically references electricity, gas, water, transportation, telephone, or internet access payments. The two qualifications to that is that all those payments have to be connected to the business, and they had to be in existence before February 15th, 2020. The second is the 75% rule, and so the SBA has, issued in their rules that only 75% of the loan amount that will be forgiven has to be for payroll costs. And so only 25% can be for that non-payroll cost business needs. And this has come up a lot in the last few weeks, based in part on an Inspector General report that noted that that rule is really not in the CARES Act. It's not statutorily based. It's something SBA instituted themselves. And as businesses are going through spending the money, there's been some attention drawn to that maybe at this point in time they need more money for their allowable non-payroll costs as compared to their payroll costs. So there's been some chatter about whether or not that 75% rule will go away. As of right now, it hasn't, but it is important to note that because it's not based in the CARES Act, congressional action would not be needed to change it. Congress obviously could step in and pass a provision, but if the SBA decides on its own to rethink that, they could change it. But as of right now, that 75% rule is still in place. The other thing that's been getting a lot of attention is this requirement that the loan period only covers 8 weeks or 56 days. And again, there's been attention that maybe businesses would need more time to spend the money. But this one is based in a statute. So the CARES Act itself says, it's 8 weeks is 56 days. So if it wanted to be extended, Congress would have to step in here and act to change that. So as of right now, both that 75% rule and the 8-week period are still in place. And then finally, with the review process, the borrower is going to have to go and submit the loan application. It has a lot of schedules and calculations. It's about 11 pages long. And then the lender has 60 days to review it. The SBA has officially said in the guidance and the loan application that they will be directly auditing loans that are greater than $2 million. And again, all non-forgivable loan amounts have to be repaid within 2 years at that 1% interest rate. Okay, so we've used this slide before in previous webinars. We just discussed that 75% rule. But to review again, that advance, idle advances that we've talked about in the past, if a business got one, any amount of that loan is going to be deducted from the PPP loan amount. But I really want to focus on that last bullet point that says forgiveness is based on the employer maintaining or quickly rehiring employees and maintaining salary levels. So forgiveness will be reduced if full-time headcount declines. Again, those independent contractors don't count as employees. And forgiveness is also be reduced if salaries decrease by more than 25% for an employee. That does not apply to employees who make more than $100,000. And the reason I'm focused on those two is both of those calculations are covered more extensively in the guidance that just came out. And so that's one of the topics we'll be covering in more detail in the future. I just wanted to note that that is something we will be covering. Okay, so I wanted to cover for everybody quickly today the loan forgiveness calculations that are in the application and the new interim rule that apply to the payroll and non-payroll costs, because businesses that have loans right now are already spending this money. So again, payroll has to be incurred or paid during the 8-week period of the loan. But the application and the rule that SBA just issued says that this can be 2 different types of 8-week periods. So the basic one that was available before was that 8-week talk would begin ticking at the date of loan disbursement. That's referred to as the cover period in the SBA materials. But for those businesses that have a biweekly or more frequent payroll cycle, the SBA is affording them a second option. So this option is called the alternative payroll covered period, and it will start on the first day of the first payroll cycle in the covered period. And so what it does is just align that loan more in tune with the business's payroll period. But again, that's only available to businesses that have a biweekly or more frequent payroll cycle. So as an example, a borrower does have a biweekly payroll schedule, which is every other week. So its 8-week covered period begins on June 1st and ends on July 26th. The first day of its first payroll cycle that starts in the covered period is June 7th. So under this provision, the borrower could elect that alternative payroll covered period that would start on June 7th and then end 55 days later on August 1st. So payroll costs that are paid during that time period are forgivable, but payroll costs that are also incurred during that alternative payroll cover period are also forgivable under the new rules. So as long as that business pays on or before the first regular payroll date occurring after August 1st, that amount will be forgivable. But the SBA does note that costs that are paid and incurred during the periods can only be counted once. So you can't double dip with how you're calculating what's forgiven. Okay. And so then with non-payroll, again, the SBA is allowing non-payroll costs that were incurred or paid to be eligible for forgiveness. So as long as it was either paid during the covered period or incurred during the covered period and paid on or before the next regular billing date, it will be forgivable even if that billing date is after the covered period. And so an example of this is if the borrower had a covered period that began on June 1st and ends on July 26th, it pays its May and June electricity bill during the covered period, and then it pays its July electricity bill on August 10th, which is the next regular billing date, but after the end of their covered loan period. And so the May and June electricity bills were paid during the covered period, so they're forgivable. But that portion of the July electricity bill through July 26th, which is the end of the covered period, is also forgivable. So it was incurred during the covered period and paid on the next regular billing date. So those utility bills can only go through the end of your covered period, but even if you pay them after, they will be forgivable. And just, we don't have this here. This is another thing we'll be putting out more details on. But the SBA has issued more details about the documentation they're looking for both payroll and non-payroll expenses. So definitely be on the lookout for us to put out some stuff about what those documentation requirements say. Okay, so one more thing I wanted to cover, because this is affecting businesses right now. So our last webinar, we had covered this rehire exception that the SBA has instituted. So the CARES Act gave the SBA authority to establish de minimis exceptions to the limits on loan forgiveness under the Act. And so remember that the statute says if a business doesn't keep the same amount of employees, their loan forgiveness is going to be cut back on a kind of pro rata formula basis. But the SBA has issued this de minimis exception. It's in the latest guidance officially that laid off employees whom the borrower offered to rehire are excluded from that reduction calculation. And it's also going to apply to employees who had their hours reduced as well. But the borrower has to meet some specific requirements to get this exception applied to them. So they have to make a good faith written offer to rehire or restore the reduced hours of the employee during either the cover period or alternative payroll cover period. The offer has to be for the same salary or wages and the same number of hours as they earned before their layoff or reduction. The offer has to be rejected by the employee. Borrower has to have documentation from the offer and its rejection. But what's new in the guidance that was issued on Friday is that the borrower has to now inform the state unemployment office that the employer rejected their offer of reemployment within 30 days. So before we kind of were just saying that, you know, it may affect the employee's unemployment status, but now the borrower affirmatively has to go to the employment office and say that they had an employee reject their offer of reappointment. And right now we don't know what the details of how that's supposed to happen. SBA says they're going to have it on its website. As of right now, it's not there, but that's definitely something for businesses who are facing these employees who don't want to come back need to be aware of if they want to take advantage of this exception in the CARES Act.
Great. Thanks, Zach, Kathy, and Tara, so much. So I know that was a lot of information. I'm going to launch a poll because we're curious as to what other information people might be interested in learning about future webinar topics, but we also want to give folks a chance to ask questions through the chat box. And I want to thank everyone again for joining us today. I hope that these are helpful. The more information that we can hear from the programs about the questions that you are receiving from your stakeholders, the more targeted our outreach can be. The National Sea Grant Law Center is planning on using the rapid response funding that's being offered by the national office to bring on more students and to kind of ramp up the materials that we're able to get out here in the next couple of months. And so, yeah, just keep your questions coming and let us know. And let me check the chat box. So Kathy, there's a question about the PPP. So is the 75% payroll and at least, could we do 80% for payroll and 20% for non-payroll? Oh, yeah, I think Pete might have answered his own question. Yes, you can do more than that. You could do 100% payroll.
Yeah, exactly. There's no limit on the payroll. It's just the limits on the non-payroll side.
So there's a question, are liability waivers applicable to fishing crew contracts? So Gabe, it would depend on what is currently in their contracts. There may already be liability waivers in those contracts, just because they can be hurt, you know, lots of different ways on a fishing boat, I'm sure. But so that's the first place to start, is to see what's currently in the contracts, and then yeah, fishing captains and businesses probably can add those to crew contracts. But again, as Tara mentioned, it's very dependent on state law, how enforceable waivers of liability are. Will USDA consider making additional seafood purchases in the future? Is that opportunity closed? So with respect to that Section 32 program, because that is an ongoing program, it's my understanding USDA can choose to purchase buybacks as the need arises. And so I think the existing seafood purchases were kind of a result of lobbying by congressional delegations like in Alaska and Maine. And it's possible that the USDA could put offers out for different species of seafood in the future. So that would be the agricultural marketing service that Zach mentioned. It would all be funding dependent, but Sea Grant folks should kind of keep an eye on that program and that website to just see if there might be the opportunity for other seafood purchases in the future, funding dependent. Great. Okay. Well, I don't see any other questions coming in. Thanks again, everyone, for joining us, and thanks for taking the poll. Looks like a lot of good feedback for the poll. Please vote before you sign out, and we look forward to seeing you again on our next webinar. Thanks.